Apple just sued OpenAI over alleged trade secret theft, and this morning's lawsuit could reshape how every AI company on Earth protects its intellectual property. The allegations are severe. Apple claims that OpenAI accessed confidential information about voice AI technology during private partnership negotiations, then used that stolen knowledge to build competing features into ChatGPT's voice mode and other products. Think about what this means. Imagine you're a master chef consulting with a restaurant chain. During closed-door conversations, you share your exact techniques, ingredient ratios, and preparation methods that make your dishes legendary. The restaurant decides against partnering with you, but then suddenly launches a competing menu using those precise same methods you just revealed. That's trade secret theft. That's what Apple is accusing OpenAI of doing. But here's what makes this different from a restaurant dispute. We are talking about AI technology worth billions of dollars. Voice recognition systems that work privately on your phone without uploading your conversations to the cloud. Competitive advantages that took teams of engineers years to develop. The scale of what's at stake is staggering. This isn't just Apple versus OpenAI. This is a watershed moment for the entire AI industry because it exposes how fragile trust has become between partners. If even the biggest, most powerful companies can't protect their secrets from each other, what does that mean for smaller startups and partnerships going forward? To understand why Apple is taking this step, you need to know what Apple and OpenAI were doing together. A few years back, both companies made a big announcement. They were exploring deeper integration between ChatGPT and Apple's ecosystem. The plan was to bring OpenAI's conversational AI directly into Siri, Apple's voice assistant, and other Apple products and services. On the surface, this looked brilliant for both companies. Apple gets access to cutting-edge language models without building them from scratch. OpenAI gets integration into a platform that reaches 2 billion devices worldwide. Win-win, right? But during those partnership discussions, the private meetings, the confidential technical deep dives, Apple shared something with OpenAI that they consider absolutely proprietary. They revealed how Apple builds voice AI systems that prioritize your privacy. Not just any voice recognition, but specifically how to process speech on your device, locally, without sending your audio files to remote servers where they could be stored, analyzed, or sold. That's the core of Apple's competitive advantage in voice AI. Every other company, Google, Amazon, Microsoft, they all want your voice data in the cloud because they can use it to train AI models and target you with ads. Apple built an entirely different architecture. They convinced customers that your voice stays yours. The lawsuit alleges that OpenAI paid careful attention to everything Apple shared about that architecture. And then, according to Apple, they used it. So what exactly is Apple claiming OpenAI stole? The lawsuit documents allege that OpenAI accessed protected information about Apple's proprietary approaches to on-device voice processing, privacy-first AI architecture, and real-time language understanding that works without cloud connectivity. Here's why that matters in concrete terms. When you say something to ChatGPT's voice mode, every competing voice AI in the market does essentially the same thing. It sends your audio to a remote server, runs the processing there, and sends the answer back. That takes about 500 milliseconds round trip. Acceptable but not instant. More importantly, your voice lives in the cloud. Someone could theoretically listen to it, store it, or use it for training data. Apple's approach is fundamentally different. The company built AI systems that can process speech locally. Right on your phone, your voice never leaves your device. The processing is faster, under 100 milliseconds from speech to response, because there's no network trip. And your privacy is architecturally guaranteed because Apple doesn't need to store or transmit your voice anywhere. The lawsuit suggests that OpenAI incorporated these privacy-first principles and on-device processing techniques into ChatGPT's voice mode after learning about them during partnership talks. If true, that's not just copying an idea, it's taking years of engineering research and billions in development investment and deploying it without authorization. Apple calculates that this trade secret is worth somewhere in the range of billions of dollars in competitive advantage. and they are taking OpenAI to court to prove it. Let me show you exactly how this technology works so you understand what's at stake. When you use your voice on Apple devices, there's a complex dance of AI systems running to understand what you said, interpret your meaning, and generate a response, all without your audio ever leaving your device. First, your phone uses on-device speech recognition. That's a specialized AI model, often only 10 to 30 megabytes in size. That's designed to run fast on your phone's processor without draining battery. It converts your voice to text in real time. Then a second AI system, a language model also running locally, reads that text and understands context, intent, and nuance. Now here's where Apple's proprietary systems come in. The company has built specialized techniques for handling the fact that everything happens on device. How do you update these models when there are millions of devices? How do you personalize them to individual users without storing data in the cloud? How do you handle the edge cases where the device internet connection is slow or spotty? These are not simple problems, and Apple's solutions to them are what the company considers its trade secrets. OpenAI's traditional approach with ChatGPT is different. They built massive language models that live in data centers. Your voice goes up, their servers process it, and the answer comes back. This lawsuit isn't the first time tech companies have fought over trade secrets, so let's put it in context. In 2019, Qualcomm sued Apple over chip designs and licensing. That case ended in settlement. In 2023, NVIDIA and Samsung had disputes over chip architecture. But this Apple versus OpenAI lawsuit is different in a crucial way. It's about AI intellectual property in the exact moment when AI is becoming the most valuable technology on Earth. Compare it to when Google allegedly paid billions for Android patents after rejecting licensing deals, or when Facebook acquired Instagram and WhatsApp partly to eliminate competitors and gain their technical innovations. Those acquisitions were transparent. Both companies openly acknowledged the value they were acquiring, but alleged theft of trade secrets is fundamentally different. It's not a payment for IP, it's unauthorized use, and the damages can be astronomical. If Apple can prove that OpenAI knowingly took proprietary information and used it to build commercial products, the damages awarded could reach hundreds of millions or even billions of dollars. But more importantly for the tech industry, precedent matters here. Consider how this affects partnerships going forward. If Apple loses and the court decides their information wasn't adequately protected, then every company has to fundamentally rethink what they share with partners. If Apple wins, then OpenAI has to pay massive damages and the entire industry gets a wake-up call about IP theft. Here's where this gets serious for the entire AI industry. If Apple wins this lawsuit, it sends a message that trade secret theft in AI development has massive legal consequences. Companies would need to be far more cautious about what they share during partnership talks. Confidentiality agreements would become ironclad, and partnerships between major companies might actually become less common because the risk would be too high. Think about what just happened. Apple was negotiating with OpenAI. They shared technical secrets. The partnership fell apart, and now Apple is suing because they believe their secrets ended up in competing products. That creates a chilling effect. Why would any company risk another partnership? Why share anything with anyone? The consequences ripple outward. Smaller AI startups often need to partner with giants to grow. If giants can't trust each other, startups have nowhere to go. Research collaborations between universities and companies become riskier. Open source communities that rely on shared knowledge and trust get defensive. The entire collaborative spirit that's driven AI innovation could fracture. At the same time, if OpenAI wins or settles quietly, it sends a different message, that companies can access each other's secrets during negotiations and face minimal consequences. That essentially weaponizes partnership talks. Every conversation becomes a chance to spy on competitors. For you as a user, this matters because it determines what products you get. If partnerships become impossible, development slows down. So what actually happens now that this lawsuit is filed? Understanding the legal process is important because this could drag on for years. First, both companies will enter what's called the discovery phase. That's where lawyers get to demand all internal communications, emails, meetings, technical documents, everything that might be relevant to the case. This is where the real story emerges. Did OpenAI engineers email each other about implementing Apple's techniques? Are there meeting notes showing discussions about Apple's proprietary methods? That's the evidence that matters. Next comes motions and legal arguments. OpenAI will almost certainly argue that trade secrets weren't adequately protected or weren't truly secret. Maybe Apple shared similar information with other companies, or maybe the technology isn't as proprietary as claimed. Apple will argue that they took reasonable steps to protect the information and that OpenAI knew it was confidential. Then there's settlement negotiations. Most cases like this never go to trial. Companies negotiate a payment, sometimes millions, sometimes much more, and sign an agreement not to discuss what happened. We might never know the true outcome. If it does go to trial, the judge or jury has to decide, was information truly proprietary? Did OpenAI actually use it? What's the financial damage? If Apple prevails, they could be awarded the damages plus attorney fees, potentially reaching billions of dollars. Meanwhile, OpenAI faces business consequences beyond just legal fees. Here's what you need to remember when this lawsuit gets decided months or years from now. This isn't about whether someone said something mean in a meeting or who shook hands first. This is about whether AI companies can steal each other's fundamental innovations and get away with it. Apple built something genuinely different, a way to run powerful AI on your device without uploading everything to a remote server. That privacy-first architecture is worth billions. OpenAI built something different too, massive language models with incredible knowledge and reasoning ability. Both innovations took years and billions of dollars to develop. The question before the court is simple. Can one company take the other's innovation and incorporate it into their own products without permission? The answer to that question will shape the AI industry for the next decade. If Apple wins, expect partnerships to become far more protective and secretive. If OpenAI wins or settles quietly, expect more aggressive IP theft disguised as partnership discussions. Either way, the AI industry is about to learn a hard lesson about trust. For you, stay tuned for the discovery phase documents. That's when we'll actually learn what happened in those private meetings. Did OpenAI engineers acknowledge Apple's techniques? Did they explicitly copy them? That's the evidence that will tell you who's really at fault here. This lawsuit is just the opening move in what could be the biggest IP battle in AI history.